requires a little more detail, and I'll ask you a couple of questions.
Yeah, because I asked for the form to fill
Right.
it out, and then I get it, so I'd like to know if the time to send it.
You said she does not have legal status, is that correct? So the question is, how did she enter the United States? With inspection or without? Without. So you can apply for your spouse irrespective of how she came to the United States as a United States citizen. The question then becomes, can she change her status? And secondly, can she change her status within the United States? If she entered without inspection, and no one applied for her prior to 2001, April 30, 2001, when the old law expired, that means she would not be able to change her status in the United States. So the first part is the bona fides of your relationship. That's the simple one. Then it becomes the adjustment of status. If she entered the United States without inspection, she's going to have to go back to her country and do what's called consular processing. Consular processing is through the Department of State, the consulate, the American consulate in her home country. And the first interview is she inadmissible? Is she a good moral person? Has she been convicted of any violations? Is there anything that would cause her to not to be allowed to enter the United States? The problem is, and this is the danger with consular processing, the moment she was in the United States for over 6 months without status, it's called a lawful presence, and she leaves, she can't go back for 3 years. If she was in the United States for over a year, it means she was over 18 years old, she stayed here until she was at least 19 years old, over 12 months of unlawful presence. When she leaves, she can't come back for 10 years. It's a long time. Now,
the law is changing.
I'm getting to that. There is a process called a waiver. That says, look, I understand that I was here without permission, but my only problem is this unlawful presence. Forgive me for that, because it causes extreme hardship to my United States citizen or lawful permanent resident spouse or parent. Children don't really count for that. That's the way the law is today. But that process is done, both of those done through the consulate, and it takes a minimum of 6 months to 12 months today. March 4th, 2013, the provisional unlawful presence waiver comes into effect. And I'll talk about it for another minute because that's not the point of this, but if you'd like to talk about it more in detail afterwards. What that says is, look, we recognize that the process today takes too long. We recognize that the person is going to be outside the United States, separated from the family for a very long period of time. So that waiver, that asking for forgiveness, you can apply in the United States. That way, before you leave, you know that the most difficult part of it has already been granted. You still need to go to outside the U.S., because this comes through the president, not through Congress. The president can't change the law; he only changes the way it's enforced. So you're still going to have to leave, but it might only be a couple of weeks or a month rather than 6 months or a year. So the provisional unlawful presence waiver, is what it's called, is specifically for spouses of United States citizens that have been in the United States for an extended period of time, and to shorten the time they're going to be outside the U.S. We still don't know what the form is, we still don't know what the filing fee is for that, and that's step 3 out of a 3-step process. So there are other things that need to be done in advance.
Is it recommended to fill out the form one day and send it, or
what I would suggest is you consult with an attorney before you do that, because the reason is simple. If you find out she doesn't qualify and she's outside the country, she's not coming back for 10 years. That's one heck of a risk to take. If it's if it's just simply filing the citizenship application, I wouldn't say simply, because there can be consequences for it. Every case is specific, but that is one where the risk is so high. Take the time, meet with someone, make sure that there's no other inadmissibility factors. What I mean by that, unlawful presence is only one category. What happens if there's prior violations? What happens if there's other instances of good moral character? If they find that there's a prior violation of something, she doesn't qualify for provisional lawful presence waiver. So forgiving for one and not getting forgiveness for the other still doesn't get her into the United States.